Friends, today we will discuss most important judgment passed by Honorable Supreme Court on 20th July 2011 by the bench of Justice R.V. Ravindran and Justice A.K. Patnaik. Name of the case is SMS Tea Estate Private Limited versus Chandmari Tea Company Private Limited. I am giving brief of this case, what happened, how dispute arises in this case. On October 2006, appellant of the case, that is SMS Tea Estate Private Limited, approached to the respondent for granting a lease, long-term lease for the period of 30 years of two tea estates. Means appellant wanted to take two tea garden on long-term lease from the respondent. Respondent agreed for the same, and 21st December 2006 a long-term lease has been executed between appellant, that is SMS Tea Estate Private Limited, and Chandmari Tea Company Private Limited. There was one clause in this long-term lease agreement, that is clause 35 of the agreement, which deals about the arbitration, which says that if any disputes arises between the parties, matter will be referred to arbitrator, and arbitrator will decide the dispute between the parties. What happens? Appellant has taken the occupation of the tea estate and they invested huge amount in the tea estate for the improvement purposes. In the meantime, respondent suggested appellant to purchase, in spite of taking the long-term lease, purchase the tea garden, tea estate for the so and so one specific amount. Previously, appellant denied, means nothing said about his eagerness whether he want to purchase or not. After some time, respondent illegally evicted the appellant from the tea estate. Thereafter, appellant agreed to purchase these two tea estate, but respondent denied the same. What happened? Then dispute arise between the parties. Friends, you know that when any dispute arise between the parties and there is arbitration clause in the agreement, first process is to issue notice under section 21 of Arbitration and Conciliation Act. In the same way, appellant SMS Tea Estate Private Limited issued notice on 5th of May 2008 to calling upon the respondent to refer the matter to arbitration as per clause 35 of the lease agreement. Respondent never replied and failed to comply the suggestion notice given by the appellant. According to appellant, the dispute between the parties related to claim of the appellant that respondent should either sell the estate to the appellant or permit the appellant to continue in occupation of the estate for further 30 years as per the lease agreement. What happened? Nothing happened, nothing doing. Respondent, not respondent, the legal notice sent by the appellant. Then appellant approached to Guwahati High Court for the appointment of arbitrator as per section 11 of the Arbitration and Conciliation Act. There is section 11 which deals with the appointment of arbitrator. If no party respondent to the suggestion or agreed on a single arbitrator, or in that case they can approach under section 11 for the appointment of arbitrator. Matter reached before the High Court. Respondent objected the appointment of arbitrator on the ground that the lease is for the long term, for the period of 30 years, and for the immovable property, that is tea estate, and this is compulsory registrable lease document, and there must be sufficient stamp duty paid for the purpose of the execution of lease deed. High Court, Guwahati High Court has dismissed the petition on this ground and said that this agreement cannot be enforced. The arbitration clause of 35 clause 35 of the agreement cannot be enforced, and arbitrator cannot be appointed for the purpose of deciding the dispute between the parties. Then appellant SMST Estate Private Limited file a special leave petition before Supreme Court, and question of law framed by Supreme Court. There is one important question of law, that is whether an arbitration agreement is an unregistered instrument which is not duly stamped is valid and enforceable. Supreme Court has answered this question of law in this judgment and held that, we are reading the relevant para of the judgment, that is where Supreme Court held that the court should, before admitting any document into evidence or acting upon such document, examine whether the instrument document is duly stamped and whether it is instrument which is compulsorily registrable. Means court held that first of all, before enforcing any document, court has to see that whether this is compulsory registrable document, or if there is any deficient stamp duty in this agreement. Second point, if the document is found to be not duly stamped, then section 35 of Stamp Act bars the said document being acted upon. Consequently, even the arbitration clause therein cannot be acted upon. The court should then proceed to impound the document under section 33 of the Stamp Act. If the document is found to be duly stamped, or if the deficient stamp duty and penalty is paid, either before the court or before the collector, after impoundment, what will happen? Matter will go before the collector, and collector will impose penalty on the document and also collect the deficient stamp duty. Then if any party paid the deficient stamp duty along with penalty, then the agreement can be enforced. Once the document is found to be duly stamped, the court shall proceed to consider whether the document is compulsorily registrable. If the document is found to be not compulsorily registrable, then court can act upon arbitration agreement without any impediment and appoint the arbitrator for the deciding the dispute between the parties. Next, if the document is not registered but is compulsorily registrable, having regard to the section 16(1)(a) of the Act, court can delink the arbitration agreement from the main document as an agreement independent to the other terms of the document. As we know, arbitration agreement is separate and independent agreement. In that case, if lease agreement if any document is compulsorily registrable document. In that case, court can delink the arbitration clause from the main agreement and appoint the arbitrator. But when there is deficient stamp duty, court will not appoint, not the refer the matter to arbitrator till the deficiency has been made by the party along with the penalty. What happened? This is the law held in this case. But thereafter, in 2019, one judgment, Garver Wall Ropes Limited versus Coastal Marina Construction and Engineering Limited, Honorable Supreme Court reaffirmed the earlier position of SMS Tea Estate judgment and said that if agreement or any document is deficient stamp duty, that cannot be referred to arbitrator for the decision of the dispute between the parties. Thereafter, then one judgment in 2021, that is NN Global Mercantile Private Limited versus Indo Unique Flame Limited and others. This judgment overruled the SMST estate and Garver Wall Ropes. This judgment said that both the judgment is not correct law. He said that in spite of the deficient stamp duty, matter can be referred to arbitrator. Then came one more judgment which said that NN Global judgment, which said that ki SMST estate, which overruled the SMST estate and Garver judgment matter, the NL Global Mercantile Private Limited versus Indo Unique Flame Limited judgment should be referred to higher bench, means constitutional bench. Finally, the matter was referred to 5 judges bench, where majority judgment of the state judgment view taken of said that view taken in SMST as followed in Garver represents the correct position in law. It was further held that NN Global 1 was wrongly decided in as much as overruled SMST estate. Means constitutional bench judgment of NN Global finally set aside the overruling of SMST estate and said that SMST estate judgment is correct judgment. That was subsequently followed in Garver Wall Ropes Limited judgment, which is followed SMST estate, that is correct law. This is the law regarding deficient stamp duty of an agreement executed for the immovable property. Friends, if you think this video is informative, kindly subscribe this and like this video. Thank you.